Good afternoon, everyone. I'm Cinnamon Carlarn, and I'm the very proud and very happy right now 19th President and Dean at Albany Law School. I want to say a very warm welcome to each of you here today. Welcome to Albany Law. I see many students, many former students, alumni, folks from the community. We're so happy to have you here. And it's a real privilege tonight to have, or this afternoon, to have the opportunity to open this year's Chief Judge Lawrence H. Cooke Symposium. This is a cornerstone event for Albany Law Review's annual state constitutional commentary issue, but it's also one of our most anticipated events of the year for reasons that I'm sure you can imagine. Now, as always, the Law Review has identified a topic of critical importance and increasing urgency, with this year's theme focusing on criminal justice on trial, failings, possibilities, and aspirations. Now, I want to begin this afternoon by expressing my very sincere appreciation and admiration for the members of the Albany Law Review for all of the work that you've done this year, from an impressive list of publications to hosting numerous really important intellectual conversations here on campus. You really are truly an inspiring and impressive bunch, and I've enjoyed working with you throughout the year. And I want to say, and I'll just add a special congratulations and thanks to the Law Review for helping assemble such an extraordinary panel of experts for this discussion. We are very honored tonight to welcome Chief Judge Rowan Wilson of the New York Court of Appeals, whose leadership and insights and deep commitment to the rule of law really set the standard for lawyers and leaders and legal education in New York. We're also honored to have former Chief Judge Jonathan Lippman, whose groundbreaking work on criminal justice reform continues to shape our legal landscape. Before moving on, I just want to offer a special thanks to both Chief Judge Wilson and Chief Judge Lippman, both of whom are and have been incredibly generous with their time consistently over the years and demonstrate this commitment to interacting with and helping shape our future lawyers and leaders. One of the great benefits of Albany Law School, as many of you know, is how being in the capital of New York allows us to have a deep and strong relationship with the Court of Appeals, but it wouldn't be possible if it were not for the generosity of the judges and the way they absolutely continue to show up for our students and community. I'm honestly not sure where they find the time, but I do know our community is very grateful that they do. Now, rounding out our fantastic panel tonight, we have two very impressive panelists. Joining the Chief Judges tonight are Karol V. Mason, President of John Jay College of Criminal Justice, and a leading voice in criminal justice education and advocacy, and Annie Rody-Wright, who's the Program Director for the Criminal Justice Program at Siena College. And last night I was at Siena College and I had the opportunity to hear from her students about all that she's achieved and all of the influence that she's had on them. And as an educator, there's honestly no higher praise. So that was a really nice way to be introduced to her. So Chief Judge Wilson, Chief Judge Lippman, President Mason, Ms. Rody-Wright, we're honored to welcome you to Albany Law School tonight. Now, guiding our discussion will be two of Albany Law School's indomitable faculty members, including Professor Bonventre, who has just been a cornerstone of this community and a wonderful link between this community and the court and education, and really helped put tonight together. So huge thank you. And Professor Dale Cecka, whose expertise in criminal justice and her dedication to experiential learning have really helped us change who we are as a community, even in a couple of years. Now, this symposium, just as a quick note, is also co-sponsored by our fantastic Government Law Center. And this really underscores our collective commitment to fostering critical conversations on really pressing and sometimes very challenging legal and social issues. The Government Law Center here at Albany Law is a critical part of who we are as a school. And the center's work and really dedication to bridging the gap between academia and public policy is ever more important now as we really think about the role of the rule of law in society. Now, before I wrap up, I want to just take a brief moment to reflect on the legacy of Chief Judge Lawrence H. Cooke, another proud graduate of Albany Law School from the class of 1938, for whom this symposium is named. Chief Judge Cooke served with distinction on the New York State Court of Appeals, including as its chief judge, and really leaving an indelible mark on our state's jurisprudence. His tenure was characterized by a deep commitment to fairness, a keen intellect, and a proud understanding of the evolving needs of our legal society. And it's particularly fitting that this symposium tonight, addressing the critical issues within our own criminal justice system, bears his name. Chief Justice Cooke's own dedication to upholding the principles of justice and ensuring the integrity of our courts serves as a powerful inspiration as we engage in tonight's conversation. So again, thank you to everyone here. And now I have the pleasure of welcoming up to the podium Sarah Midani, who is Albany Law Review's editor-in-chief and has been just an incredible leader this year. So Sarah, over to you.
Thank you, Dean Carlarn. Good afternoon and welcome to Albany Law School. My name is Sarah Midani and I'm the editor-in-chief of the Albany Law Review, Volume 88. We're thrilled to be hosting our annual Chief Judge Lawrence H. Cooke Symposium, and we're glad to have you with us. Today's program was inspired in large part by Chief Judge Rowan Wilson's State of the Judiciary speech, which he delivered back in February. In that speech, the Chief Judge highlighted a key question that affects New Yorkers in every corner of the state. Is our criminal justice system working? This discussion will delve into some of the most pressing and controversial issues associated with criminal justice reform in New York State and elsewhere, including racial disparities, domestic violence, and juvenile justice. Our panelists will explore the ways that these issues manifest themselves and the impact they have on our communities and our people, as well as what potential solutions may be out there. Now, before we dive into the panel discussion, I want to recognize Albany Law Review's executive editor for state constitutional commentary, Sophia Casaubon. Sophia has a very unique role on the Law Review. She holds the only executive editor position that oversees both a symposium and a specialty book filled with scholarly articles. State constitutional commentary is one of very few scholarly publications in the US devoted specifically to state-level constitutional issues. It's been a privilege to work with Sophia on putting together both an impactful book and a symposium that demonstrate the importance of civil rights and liberties through a state constitutional lens. Now it's my pleasure to introduce Albany Law Review's executive editor for state constitutional commentary, Sophia Casaubon.
Thank you, Sarah. My name is Sophia Casaubon, and I am the executive editor for State Constitutional Commentary for Volume 88 of the Albany Law Review. Thank you for joining us today for the 2025 Chief Judge Lawrence H. Cooke Symposium, Criminal Justice on Trial: Failings, Possibilities, and Aspirations. I would first like to extend a sincere thank you to the Government Law Center, which is co-sponsoring this event. Under the leadership of Patrick Wilds and formerly Judge Leslie Stein, who's in the audience today, the Government Law Center has been a longstanding supporter of the Albany Law Review. We are especially grateful to Chell Miller, the Government Law Center's program director, who played a critical role in putting together today's event. I have the great pleasure of introducing our panelists and moderators for today's symposium. Now, I cannot begin to address all of the incredible accomplishments of our speakers, and for the sake of time, I will not attempt to do so. Please consult your programs for more detailed biographies of today's fantastic panelists and moderators. Our first moderator is Professor Vincent Martin Bonventre, the Justice Robert H. Jackson Distinguished Professor of Law here at Albany Law School. Professor Bonventre served as a law clerk to 2 judges on New York's highest court, as well as a Supreme Court Judicial Fellow. He is an expert on both the New York Court of Appeals and the United States Supreme Court. Professor Bonventre also serves as the editor of Albany Law Review's State Constitutional Commentary issue, and we are lucky enough to have him as our faculty advisor for Albany Law Review. It is because of Professor Bonventre that we have today's Cooke Symposium, and it has been a privilege to work closely with him all year on both today's event and the upcoming state constitutional commentary issue. Thank you for everything, Professor Bonventre. Our second moderator is Professor Dale Margolin Cecka, Assistant Professor of Law and Director of the Family Violence Litigation Center here at Albany Law School. Professor Cecka has spent her entire legal career advocating for children and families, both in the public and private sectors. Her scholarship, which focuses on the constitutional rights of parents and inequities in the child welfare and family court systems, has been cited by several state Supreme Courts across the country. We are fortunate to be joined today by both current and former leaders of New York State's court system and esteemed scholars in the field of criminal justice. First, we have the Honorable Rowan D. Wilson, Chief Judge of New York State. Chief Judge Wilson joined New York's highest court as an associate judge in February 2017. He became Chief Judge in April 2023 after being nominated by Governor Kathy Hochul. During his time on the Court of Appeals, Chief Judge Wilson has continuously spoken out about the failings of New York's criminal justice system and the role the judiciary can play in reforming it. In his 2025 State of the Judiciary address, he stated that, quote, "Put simply, our criminal justice system isn't working. Maybe it hasn't ever really worked. Prolonged incarceration is very expensive, and it does not make us safer. It entrenches poverty, perpetuates cycles of violence, and harms many of the New Yorkers we are trying to protect and serve." Next, we have the Honorable Jonathan Lippman, former Chief Judge of New York State. He served as Chief Judge from February 2009 through December 2015. During his time as Chief, he championed equal access to justice issues in New York by strengthening the state's indigent criminal defense system, addressing the systemic causes of wrongful convictions, and creating human trafficking courts across the state. Chief Judge Lippman now serves as the chair of the Independent Commission on New York City Criminal Justice and Incarceration Forum, which is tasked with examining the future of the Rikers Island jail facilities. Third, we have Karol V. Mason, president of John Jay College of Criminal Justice. During her time at John Jay, President Mason launched the Future of Public Safety initiative, which helps communities reshape their safety policies, programs, and budgets. Before she joined John Jay, President Mason served as an assistant attorney general in the Obama administration, where she led juvenile justice, bail reform, and reentry programs. Finally, we have Professor Rody-Wright, coordinator of the criminal justice program at Siena College. Professor Rody-Wright has taught her criminal justice classes both at Siena College and Green Correctional Facility. And this fall, she will teach her first Inside Out course on restorative justice, where she will bring Siena students into prison weekly to learn alongside incarcerated college students. Prior to her time at Siena, Professor Rody-Wright served for 15 years as the legal director of the Center for Law and Justice right here in Albany. Thank you to all of our panelists and moderators for joining us here today. It is an honor to hear and learn from you all. It is now my pleasure to turn the microphone over to Professor Bonventre, who will begin tonight's important and timely discussion. Thank you.
Thank you so much. It's really been an honor for me to work with the law review students. 35 years. They can't get rid of me. Sarah wanted to fire me. Oh yeah, but no, for 35 years. And one of the best things is these symposia that we hold. I'm smiling over here because my favorite appellate court judge, Elizabeth Gary's over here, and my favorite Court of Appeals judge ever, Leslie Stein, is over here. But I have a symposium like this. I mean, we have Chief Judge Wilson, Chief Judge Lippman, and they're veterans, by the way. So you two are new. These two are here all the time. Once you start coming, you want to come every year. True. I got a call from Lippman. You having one of these things next year? I want to come. But in addition to these two veterans, we have these two extraordinary panelists, President Karol Mason and Professor Rody-Wright. This is really going to be a terrific, terrific event. I'm going to start off by asking Chief Judge Wilson, whose State of the Judiciary really inspired the theme for tonight's symposium. Ask him to recap some of the highlights, if you would, to get us started. Highlights of that state of the judiciary.
Well, it's worth watching. Don't watch the parts where I'm talking. That's not terribly interesting. But both this year and last year's in 2024, it occurred to me that instead of listening to the chief judge talk about statistics in one place and statistics in the other and how things have changed and what we're trying to do, it really would help people better understand what is going on in the court system to hear from people who have been through it. So that in 2024, I had a number of people who'd been through the treatment courts or alternative incarceration courts whose lives have been changed for the better because they were not treated the conventional way courts have historically treated people who were accused of crimes. And then I thought, well, let me take another piece of the system. Let's take some people, and what my thought originally was, let's see if I can get the commissioner of the Department of Corrections Community Services to agree to take some people who are incarcerated and have been incarcerated a really long time and let them out for the purpose of addressing the audience during the state of the judiciary. And everybody in my internal group that I talked to said, that's never going to happen. But to the commissioner's great credit, he said, sure. There were a lot of guardrails around it. And we, his staff and we independently made a bunch of inquiries to different people. My chief of staff inquired with a whole lot of people, interviewed them and then worked with them. But there were a lot of things I didn't anticipate really that only occurred to me afterwards. I mean, I think that I hope I was right that hearing from people themselves instead of hearing from me better explains what's going on. And so I think it's almost not so much what anybody said, but it's who was saying that made a difference. But things that I didn't anticipate were, what would it be like for somebody who was incarcerated for 28 years to put on a suit, which maybe the person had never done before, and to not learn that instead of actually doing this by video, not learn until the evening before that they were going to be taken from prison and brought to the Court of Appeals and speak to an audience. And then what would it feel like to return to prison, not know if you're ever going to leave again? Those things didn't occur to me. I'm glad they didn't, because I maybe would have thought twice about what I had done. But there's sometimes always happy endings. So one of the two, Ms. Eldridge, who maybe will never be released from prison, was asked by Marymount, where she got her degree while in prison, to be the commencement speaker this year. So the basic concept, and it's basically what the basic message, I think, if I want to recap the substance of what people said, is fairly simple, I think. It's that they understand that they did something pretty terrible, and they regret that, and they would take it back if there's any way they could. A lot of people say that. I think the people who came and spoke genuinely felt it. But the other part of it was that, when they did something when they were 19 or 20 or 21 or 22, they were not the same person they are now. And that we should be asking ourselves a different question, which is, what is the right thing to do now? It may well have been the right thing to do 30 years ago to sentence somebody to life in prison. But is that the right thing now? And those are different questions.
I'd like to ask
Yeah, can I comment to that?
Judge Lippman, he also used to give State of the Judiciary where he would
Yeah,
talk
I vaguely remember that.
instead of just numbers.
No, but what I want to say is that, as you indicated, I did give a number of state of judiciaries and a number of criminal justice initiatives, and tried not to just give numbers, and went into some detail about why it's a good thing, whether it was bail reform or exoneration of people. But I found so interesting and so effective what Judge Wilson did, in that it translated new ideas into real human beings. The criminal justice system, if nothing else, is about real human beings. And what could be more graphically demonstrated, especially the nature of what went on that day. You had people who had served so many years and may have been finally released after 25 years or whatever, or people who have served so many years, gotten graduate degrees and higher education, and are still sitting there in those places because of the one terrible thing, as the judge indicated, that they did. So the one thing I want to say is it really moved me in seeing what they had to say in a way that chief judges even can't project. We can talk about different ideas. Gee, wouldn't this be great for the criminal justice system? This demonstrated what the criminal justice system was all about. And then when you think about the new ideas in this particular case, the featured thought was, gee, maybe after so many years, there should be a way for people who don't need to be incarcerated anymore to maybe be released at some point if they've served, their debt to society. So I found it moving and so interesting as a way to look at criminal justice issues through the eyes of human beings who are part of the system. So I thought that was just great.
You said this was a conversation. Can I go ahead and butt in and give my 2 cents too? I told Judge Wilson when I saw him tonight, and he's been to John Jay many times. He's phenomenal in terms of getting out there, as is my boss, Judge Lippman. I'm on his commission. But I will say that I was in tears reading the report. I didn't see it. I prefer to read things because then I can mark them up and highlight them and make notes on them. And I will say, as somebody who, when I was at the Department of Justice and was responsible for funding a lot of the initiatives that people will talk about today, it really makes a difference when you hear from people who are impacted. We have these wonderful notions of what we think policy-wise we should be doing, what should work. But I will tell you that when I went to Sing Sing, where Judge Wilson was there too, as was Judge Zayas, and we didn't get to speak. We heard from the men at Sing Sing, many of whom will never come out, and hearing their stories and hearing what they're doing with their lives and hearing their hopefulness in spite of the fact that they may never get out, really crystallized things for me in a way that, okay, I'm doing all this policy work, but what's it really like, to what Judge Lippman talked about? These are real people, real people's lives. And now I'm on this kick, I can't find a better word right now, is how do we change the system so that people who have no business still staying in prison are still there, and their talent that we could be using is not here and accessible to us. So it's not just that they've paid their, I hate the word debt to society, but that their contributions that they should be making, could be making, that we all need, and we need to rethink our system of punishment. You guys are in law school, and I was telling her I graduated 43 years ago. Yes, I'm old. And when I went to law school and took criminal law, we thought that it was about punishment, retribution, rehabilitation, and deterrence. Well, those old antiquated notions need to be rethought, I think, now. And why are we keeping people incarcerated? What purpose does it serve? So I'm glad that this next generation, will hopefully do a lot better than we did in rethinking these policies and changing them.
Yeah, and I want to jump in there. Can you hear me? I want to jump in there and say, just on April 4th, Maryland passed the Second Look Act, which allows a second look at people who have served for their version of it. So 4 states and DC have passed a similar thing. We have just introduced it to our legislature as well. But I'll just explain that in Maryland, the version that passed is that after serving 25 years, your case can be looked at again. And they can see if you deserve to come out. But they also, anyway, but in the version that's been introduced into New York is that after 10 years or half of your sentence, so if you're serving a 25-year sentence, it'll be longer than 10 years, they will relook at your sentence. But there's a presumption that if you're over 55, I'm sorry, when you would be resentenced, or you were younger than 25 when the act was committed, there's a presumption that they will look at that they will resentence you. They will look at your application. So the thing about Maryland's is there is a carve out for if you're serving, you have to be parole eligible in Maryland. I don't read that in New York's version, which is great. because that would mean that anybody serving life without the possibility of parole in Maryland can't get relooked at. And the thing is, we look at the crime curves and people commit crimes till they're 26 and then it starts to drop.
Yes.
And what's also interesting about that is that that's when the brain is fully developed, right? So it's in these second look acts are really, really important because they're giving people a chance who committed an act possibly before age 25 when their brain wasn't fully developed to have that chance someday of freedom.
Can I just add one thing I think goes to the second look approach that the chief judge mentioned in the speech and the professor's talking about? It goes to something Karol said. What's the purpose of the criminal justice system? We've dealt with this on Rikers. Is the purpose all about punishment? Isn't that why Rikers is such a miserable, horrible place? Because it's punitive. That's what the correction officers learn. That's what we think being there is about. That's not the way it is every place in the world. And it all goes to looking at the criminal justice system, maybe in a different way than we've done all these years, that it's not just about saying, gee, we want to punish these people, then we're going to throw away the key. You've heard that expression so many times. That's not what it's all about. There's got to be other purposes to the criminal justice system. And in other parts of the world, they recognize that. And I think we don't. So it goes to the heart, I think, of some of these issues that the chief set off in his speech.
It's also, I think, important to think about the criminal justice system in a much broader way. Maybe we shouldn't even call it that, right? And this is an important point that President Mason made. What we would really like to do is not have people commit crimes in the first place, right? If we could do that, then we wouldn't have to worry about punishing people or incapacitating them, rehabilitating them. So suppose we're trying to talk to an at-risk 14-year-old or 15-year-old or 16-year-old to try and divert them out of a path that's going to wind them up in prison for 25 years. Can I do that better? Or can somebody who's been incarcerated for 25 years, who is now a different person, do that better than me? I know what the answer to that is. That person can do it. And that's President Mason's, one of her points is, we should not just think, and I really hate the idea of debt to society. I don't even know what debt to society means. But what we really have to ask again is, what is the reason we are keeping this person incarcerated now, right? And part of that question is, what can they do? What will they do if they're outside? And it's not just they won't hurt anybody. That's an important part of it. But it's, can they also help people? And when you see what some of these people are doing on the inside, they're not just helping themselves by getting advanced degrees. They are actually helping other incarcerated people improve themselves. And that gives you some confidence when you're looking at it, giving somebody a second look, that if you release them, they're actually going to be a net add to society. And that has to figure in the balance of two things, of what we decide about them, but also what we think about the criminal justice system. It's the entirety, and I think this program kind of captures that. It's really soup to nuts.
But you know, I'd also add what you mentioned in your speech, that it's a continuum, that there's various places along this continuum when the person could be prevented from having this miserable life of being incarcerated forever. So stop them before they get to that point, you know, or at various stages of the criminal justice process. And then you get to the end stage where, you know, you're talking about the second look and we're there, but God willing, gee, if we could stop it at some of the other entry points in and through the system, wouldn't that be wonderful also when you talk about how you look at the criminal justice?
So I know you guys want to ask questions, but this is just, I can't restrain myself from interjecting. So one of the things when I was at the Department of Justice that I remember then Attorney General Eric Holder was saying, I loved your language about the off-ramps, but he had the privilege of serving as a judge before he became the Attorney General. And he said he looked at the people who were coming before him and looked at their files before he sentenced people. And he said he looked at every point where there could have been an intervention that would have kept them from ever coming before him. And it really starts, if you, shameless plug, look at our future public safety report. It talks about the investments we really want to make in people in our communities long before they ever have to get to the off-ramps or the exits. And we ought to be investing in education, healthcare, mental health, economic development, all these things we know of. But the question is just, do we have the will to do it? And I think that the challenge today in the current climate that we're in is not losing focus on that we all share the same interest, regardless of which your political affiliation is. We want to live in safe communities. When I did our future public safety work, it was after the George Floyd murder. And I said, somebody came to me, and the National Organization of Black Law Enforcement Executives came to me and they said, somebody's going to give us $100,000. We want to partner with you. We want to develop a class. And I said, no, you don't. No, you don't. We want to go back and have a series of conversations to talk about what does public safety look like? And then what's the role of law enforcement in that, instead of just, tinkering around the edges. And I had confidence that if we got people together from different perspectives, that we could reach points of consensus, and we did. And the bottom line is, we all want to live in the same kind of community that's safe, thriving, lots of opportunity. And I don't like the phrase at risk either. The young folks, when I was doing this work at DOJ, said, call us at opportunity. We're not at risk, we're at opportunity, and you just see us as having opportunity. So if we're willing to really make the investments to give everybody the opportunity to have the same kind of communities that we want to live in, it's so much cheaper when you look at what what he put in his report. It's so much cheaper if we invest on the front end rather than keeping people incarcerated, but I will try to restrain myself and let you ask questions now.
Well, and when you talk about desistance, right? So it's school of thought that when the day that you enter prison is the day that you should start planning for the rest of your future. But it should really start way back, Head Start. And so if you want to talk about desistance, how to keep people, in case you're not familiar with that word, how to keep people from going back once they come out, right? We want to give them the resources, and maybe that includes skills, but also just the transformed brain to want to stay home, to know how to stay home, to provide for their families. Nobody wants to be in prison. Everybody wants to be able to provide for themselves and their families and take pride in it. Everybody wants agency, right? So we want to be able to give them what they need to be desistant. And I think one thing that's been a great thing in our area is LEAD in terms of diversion. So law enforcement assisted diversion. Albany was the third city in the country to have LEAD. It was Seattle and Santa Fe, then us. And Chief Albany Police Chief Brendan Cox, who was chief at the time, left to run LEAD and then was just called back by our mayor to be the chief again, interim. Runs this organization. So they divert people who are frequent flyers on the street, who they recognize, who they know, they will divert to services instead of arresting them. And one of the main goals of LEAD was to combat the disproportionality of Blacks and Latinos being picked up, especially youth, Black youth. And it's working, right? I mean, he's left now, but he's trying to run a very LEAD-oriented police department. It takes a lot of teamwork and a lot of buy-in from other police officers, but it really is an important step towards, I think, towards desistance, towards keeping people home where they need to be.
How do you relate that? What happened in New York City not so long ago with stop and frisk, when we took people of color and almost forced them into the criminal justice system instead of diverting them away from that. So there's different ways of looking at how you approach this problem, some better than others.
Yeah, and at its height, it was like 880,000 people were being stopped every year, most of them Black and Latino.
Well, it was indiscriminate was the problem. It was indiscriminate.
And less than 2% had anything on them.
Well, after my younger brother, who's in his 60s too, was second career was teaching in Harlem, and he got stopped. And he said, he looked at the police and he goes, "Really? Look at me. Why, this is why stop and frisk is bad." And I mean, it was endemic. And if you were Black and a male, certain places you just got stopped. And that's, okay, well, I won't get on the soapbox about that. We all know that that doesn't work.
I had a question. You spoke a lot about on-ramps, but exit ramps, when our laws prevent, and so many private organizations or companies prevent people exiting the incarceration system from actually obtaining meaningful or even any employment whatsoever, we need to have things in tandem with, as you said, second chance programs. So how how do you see that working together, or what is being done? Because we all know job applications, felon, check off, and you will not, be called, and that's just a tip of the iceberg of all the other.
There are a lot of problems with that. And the guys that I worked with, when I worked at the Center for Law and Justice, most of the people I worked with were male.
Mhm.
Coming home, and they said, it's great that I'm learning how to do car repair behind bars, but I come out and cars are completely computerized. Working on cars from 1975. I have no idea how to use those skills out here. And another issue was, so the skills were outdated. Frankly, women were in call centers. That was the skill they were given, and were welding and doing car repair. But also there was this problem where you could get a certification behind bars, like be a barber, and then you come out and your parole restrictions say you can't use scissors.
Right.
So there's all kind of stuff like
But you
that.
know what, Professor, I'm a big critic of what they claim passes as education in some of these places. I know in Rikers, which Karol and I have had a firsthand look at, you go to the jail, and I'm sure you've had this experience, and you think that this is the greatest thing in the history of the world as to the education that they're getting, and it prepares them for God knows what. And when you leave, because we get it from those people who are incarcerated, that's not what goes on a daily basis. It's a show, and I don't think so much of what we're talking about is the investment of resources, which really doesn't get made, but the politicians like to puffery and say, gee, and we give them this is good, and they get so many hours every day. And it's been my experience, at least, in looking at these programs, that the talk doesn't meet, what actually happens. And while there are fault lines along, what you're saying in terms of it's not up to date, I think it's just abysmal in most respects, and the proper investments are not being made, despite all of the gibberish about how much they're doing in New York City and elsewhere.
But there are some things that can be done and are being done in some places. We just need to double down and commit to them.
And focus on those
Yeah,
places
yeah.
that are doing it right.
Yeah, so I know that the Clean Slate Act will be helpful, expunging people's records over time so that so it's not a barrier to employment. When I was in the administration, we worked really hard on ban the box and beyond the box to make sure that that was not a criteria for being able to be employed, that you take off that question off of applications. And there are a number of national employers who've done it and have great success. Home Depot was a big champion of it. A lot of hospital systems do it, because the jobs have nothing to do with their abilities so I think that it takes a commitment from the private and the public sector. I think it takes a commitment to making sure that while people are incarcerated, and I have great confidence in our new commissioner, and I love his phrasing. If you didn't watch Chief Wilson's report, watch it. He talks about they're in their care. And I think that's the most important thing.
Corrections.
Right, but understanding that the people who are incarcerated are in your care, and that you ought to be thinking about what they're going to be like, because most people will get out. And the question is, how are we preparing them to come out? And so I think that a number of things need to happen. Again, the public, while they're incarcerated, they need to be thinking about programs that really prepare them for the real world, not the world it was when they went in. I think we need to make sure that private employers are willing to invest in people coming out, because they're great employees. And there are a number of folks who will testify to that. There are a number of educational programs happening in colleges now that Pell has been restored. TAP is available here in New York State. John Jay and many other colleges run programs inside systems. And at John Jay, we have something called the Institute for Justice and Opportunity, which works with people who are justice involved. And the leader of it is somebody who was justice involved. That was really important to me to do that. And it really helps people to, what Judge Wilson said, to have people who've been in the system talking to people. They're much more credible, you use the term credible messengers, but they're much more credible folks in this work when they say, I've been you, and I know what it means like, and I know what we need to do. And Andre's leadership changes how we are investing in these programs and what we're doing at John Jay, because he has a different perspective on it because he was there. And it's not just a theoretical, I think I know what's best. No, he knows what's best. So I think there are things we can and should be doing and are doing. It's just a matter of, again, what's our level of commitment to really investing in these things and staying with them for the long haul. I think too often that things happen in political cycles, and realizing that if you want real change, public health will tell you through a public health lens, change gets generational, can take 10, 15, 20 years, not an election cycle. And when bad things happen, doesn't mean you abandon it. You keep learning from it, keep pushing, keep investing, keep doing, keep studying it. And I don't know that we have had the will as a country to continue to do the things that we know should work and can work, but we don't stay with them long enough.
Well, I think that it's we could start with technology, because it's shameful that people come home from prison and they don't know how to use a computer. You have to use a computer to apply for a job these days. You cannot go in to a Dunkin' Donuts, get a paper application. Everything's by computer, and they don't know how to use computers in New York State because we don't have them. They have word processors. They don't have computer software that teaches them anything. They don't know how to use cell phones, a bank card, any of that stuff. It's all new to them. And we could start there if we really cared and if we really wanted to put our money where our mouth.
Just to push back a little bit, how would you propose, I guess, maybe the word is not rehabilitate, but so many people are incarcerated for domestic violence or things that are not, that may not be resolved once they get out, and there's lots and lots of debate about what the appropriate response is. I don't mean to get us totally sidetracked, but it's not just train someone for a job and now this cycle of violence is better, and now this person is a good parent, and now this person is functioning in the family relationship in the way that we might want. So what?
Yeah, but you know, and I know you're raising it for that reason, that the whole science of domestic violence, when the chief was talking about the year before doing the specialty courts, we have these domestic violence courts that understand that you can't treat these like normal defendants.
I understand, but I work in these specialty courts and they don't necessarily have any different of an approach. And the outcomes are not, we haven't reduced domestic violence. We haven't fundamentally altered why we as a society are solving problems in this way as young children growing up as adults. And being sent away does not does not teach somebody how to manage their interpersonal
But
relationships.
I think we have to,
Right.
what you're saying.
Right. But
I mean,
specialty
if
courts,
those courts are treating them the same way as every other criminal case, then they're totally missing the boat. And when those courts were first started, we understood that dealing with domestic violence advocates and talking to them about what should be the approach to people
Right.
that you can't necessarily teach to change their ways.
right. But there is also not any kind of uniform consensus on there's all kinds of programs, Duluth, a million things that have been tried, and we haven't actually agreed on we don't really know exactly what works. We also, in my experience, the domestic violence specialty courts often, in my experience, sound really good on paper, but what they actually do is just make it so that it's kind of an easier way to streamline a case and make sure that the criminal doesn't get heard before the civil, and it's kind of it is something that sounds good on paper, but is not necessarily resolving systemic problems in our society with why domestic violence exists, which goes much earlier than a point of entry into a court system.
So I think that, what we need to recognize is what we don't know, and we don't know how to address that completely. And I think that sometimes that's the issue, that, when I read some of the homework you gave us and some of the cases that you wrote a dissent in, Judge Wilson, that horrible case where the woman was thrown out of the window, and the New York police kept coming and coming and not doing anything. Those, I never thought I would say this, that, early, the easier things to tackle were the drug crimes. Then we were telling people, but that's not what most people are in for. We need to deal with the violent crime piece and issue. And who, lo and behold, I can't believe I'm going to say this, those are the cases we know how to tackle. Domestic violence, child sexual predators, the psychology of those, we don't know how to deal with them yet. And I think the question, at least unless there's some new literature out there that I haven't seen yet that says that there's an effective way to do it, you're the professor, you may know that. But I think that sometimes we have to recognize what we don't know, what we don't have what we haven't successfully dealt with, and acknowledge that and figure out how are we going to then tackle it and think about ways to study it again and think about, again, staying with it for the long term. And then sometimes abandoning things that we know don't work and stop trying them when they're not producing the kind of results we need to.
Right, just as an example, I mean, there's been batterers intervention programs for 40 years, and they have shown over and over again to not be very effective. I mentioned the Duluth program. Sorry, this is my area, so I'm just going to push back because this is so much of what is that crime that affects people across a broad range of things, involves domestic issues. And we don't know, and we also don't always study what we should be studying, like the effect of, we understand that domestic violence has an effect on children, but we don't know anything about, parenting after you out, or parenting if you're not, if, the survivor doesn't want to press charges. Is there co-parenting possible? There's so many things at intersection with family court that are not studied. So it's hard to make broad reform when many of the details are not studied. And I find that something like domestic violence specialty courts is something that is a good idea, but without so many other things in place, it hasn't reduced domestic violence.
Well, reducing domestic violence is not the easiest thing.
I know.
But let me say, one of the first things that I encountered when this science of dealing with domestic violence was first emerging was this two totally different ways of dealing with it. You had the real advocates who said, you can never make those people better, the batterers. Do not try. It is the worst thing in the world that you could possibly do. And other people took the approach more akin to a normal case that says there must be ways to be helpful. And I think the answer to your question is no one has ever figured the absolute answer. But that was always, I remember having advocates come in and speak to me and say, you don't understand. You can't teach these people. You've got to, this was an absolute view of it. And then there are other people who had gradations along the way. So you raise, obviously, a very, very difficult issue that society has not figured out, how to deal with.
That sounds like super predators, right? They're incorrigible. There's no use even trying, right?
Right, but they take an absolutist view of it, and maybe that's right, I don't know, but how do you get to the point where you can deal with it?
But the batter intervention programs, there is some slight hope in that when you inject restorative justice into the mix, there are some good results with it. And so restorative justice where you're teaching empathy, I mean, really you're showing someone the harm, the impact that they had.
Right.
That's the key.
But that's also debated about,
To show them the harm that they caused and whose obligation it is to fix that harm, and then
Right.
how we're gonna go about repairing.
right. However, criminal justice doesn't work in tandem with civil actions.
I
either.
just mean like programs behind bars to. help
Right,
people.
but a lot of people are not behind bars for domestic violence, and a lot of survivors are forced to have co-parenting relationships with
Yeah.
people who they are in abusive relationships with, because family court wants everyone to, co-parent and all these things. So I'm just bringing out some very complicated issues that are not easily solvable by like some program that sounds good on its face.
Yeah, no doubt. But the Center for Court Innovation has that cool program called Healing Connections, where it's like a 16-week
Right.
support group program for people who have been abusive to their partners. And I mean, I'll take hope anywhere I can get it.
Mhm.
So maybe if it helps a few families,
Mhm.
it's a step in the right direction. I don't think there's any panacea out there.
Of course.
Yeah, one of the other intractable problems in our criminal justice system, it seems to me, is juvenile justice. What do we do about the kids that are just at that point? Or they're not yet even near that point? What do we do about them? And a couple of things, a couple of the opinions which I put in the packet had to do with the way our courts treat juvenile justice. I mean, there was Chief Judge Lippman's dissent in the Jimmy D case. And you think, how in the Lord's name could the Court of Appeals allowed that kind of interrogation? And even more shameful than that, I mean, the Central Park 5 case, People versus Salam. How is it possible that Judge Tatone was the only one that knew there was a problem there? So what can the legislature do? What can the courts do in addressing this huge problem of juvenile justice? I know that's an incredibly broad question, but I just like to get the ball rolling.
We've tried to do a lot of things, or the legislature has. The whole business, the raise the age business was directed towards that. In Jimmy D, the case that you're raising, which is an issue of whether a Miranda warning that originally was okay when the child is taken away from his mother and has no one to guide him, and the police almost trick the juvenile into doing something. If Miranda was real, that, he would never have done. We can help you if you'll admit that you committed this crime. It was inconceivable to me at the time, exactly what you say, that how could we allow that to happen? But it's such a tricky area. There's another case that you had in there, I guess, was it Vito?
Versus Salam, the Central Park 5 case.
Where the mother was there and the mother was there and your present counsel was there. That's that case, yeah, that was, and in that case, they didn't realize that the child was really not 16 at the time.
Yeah.
But all of those things are so hard to understand in the modern age, that we have to treat children as children. And that's what some of these legislative initiatives are about, like raise the age.
So, I mean, I think you're asking a couple of questions in that one question. And so I would start with, again, how are we keeping young people out of the criminal justice system, period? Starting there. And if you bring down the number of them involved in the system, then you have fewer that you have bad facts and bad cases about. And we do know what works. We just aren't willing to make the investment in schools, the investment in mental health, the investment in health, the investment in developing parenting skills. There are all these things that we know what to do. We just need to have the will to do them. And they are successful when people do them. And so that you reduce the number of young people who come in contact with our system, stop criminalizing growing up. Stop criminalizing in minority communities the things that young people do that are part of growing up and development. And to your point earlier, the brain doesn't stop developing, particularly for men, until around 25, 26. I mean, but those are the facts. And we need to really have policies and practices that understand this, invest in this. But to the extent that you then still have young people in the justice system, we need to make sure the systems recognize and treat them as if they are still developing and that they're not left unattended to when they're having conversations with law enforcement.
That was what science of adolescent brain development, what that whole discussion was about, and raise the age.
Right.
And yet, after all these years, there are still issues of understanding that very basic premise, you know?
And what's so interesting to me is I grew up in New York, but I'd been away for so long to realize that New York is really behind the curve in what a lot of other states are doing, that you all are just doing raise the age in the last, 5 years? That's, other states are way ahead. And I think that we need to look at where it's being done successfully and replicate it here and not just think because we're New York, we're smart, we know things, we're progressive, we're better. No, not on a lot of these issues, and people are doing it well in other places.
Last two states to raise the age, by the way, and
Yes.
also, I just want to mention one thing you said about certain communities over police and surveilled. And I was watching a panel one time, and there was a judge in the panel who said, my friends and I in high school, we did what every kid does. We were drinking behind the wheel and we were doing drugs. You know where my friends are now? They're accountants, they're doctors, they're lawyers. And he had grown up on Long Island. And I never forgot it because it's really, really true. Over surveilled populations, they end up in the criminal justice system where other kids are allowed to be kids, right? But the other thing, I just want to give a shout out to the Right to Remain Silent bill, which just passed the assembly, and it allows juveniles to have a parent present before the Miranda's even read. I think Julia Salazar introduced it. Very exciting. It's about time. But I also want to give a plug for JCAB. So we have this great thing in Albany. I think it started in 2011. I found out about it in 2015, and by 2016, I was a devoted volunteer. But I go like once a week to hear cases of where juveniles have done something wrong, they've gotten arrested, and we divert their cases. And the really exciting part about JCAB is that you feel like you're changing lives. I feel like, what I do in the classroom is important, but what I do in JCAB is the most important thing. Because each kid's life, I feel, is a little bit different when we leave. And just to use the words of a restorative justice facilitator I worked with a couple of summers ago, you're giving these teens a hook for change. You just got to give them a hook. And if they don't know what options exist, like Governor Westmore said, you can't hit a target you can't see. And if you give them that, you show them where the target is, show them what their options are, they're going to take it. They don't want to be selling drugs on the street, right? To make money, to pay the rent. They want to be normal kids. They want to be having a successful high school experience and college experience maybe, and a future life, right? And so at JCAB, what's exciting is not only giving the kid the hook for change, but also looking at the systemic reasons for why is that kid selling drugs on the street corner at 13? Why is he not in school? What is wrong with our community that forces this kid to be on the street corner selling drugs, right? So we're looking at systemic reasons. We try to sort of get to the root of those too. And, just quick example is that there was this young girl, I won't name the high school around here, who was forced to wait outside before school started. It was a freezing cold winter day, but she got there too early and they wouldn't let her in because she wasn't an upperclassman. You had to be in 11th or 12th grade to get in early. If you're in 9th or 10th grade, you had to wait outside. And she was freezing. So she did what any kid would do. And she got on her cell phone. She said, I'm going to shoot up the school. For which she got suspended. And when we got her in JCAB, we said to her, did you think about there might be some other options you might have pursued? Did you think about maybe you could, I said to her, I totally understand why you were angry. That is a ridiculous policy. I'm going to tell you right now, it's a ridiculous policy. But maybe a way to handle it would be make an appointment with the principal and see if she can talk to you and you can tell her why that's a ridiculous policy. And she said, I could do that? I said, yeah, you could do that. And when you do that, you show all of your friends that doing things like that can make a difference. You're advocating for yourself. So that's what's exciting to me about JCAB, really giving kids that hook.
Let me raise an issue and ask the chief if he has a view on this. What always struck me is that there aren't enough judges in the appellate courts, even going up to the high court, of a background in family court, in juvenile justice. Do you think that's a problem? I mean, that always struck me that half of us don't know what the hell we were talking about in the kinds of cases that Vin raised. You see that as an issue?
There are a lot of, I think, problems with juveniles and family court. I don't think those are concentrated particularly in the appellate courts. The problems I see are a little bit different. One is that for a very long time, there simply weren't enough family court judges and support for the family court judges at that level. So, several years ago, well before I was chief, I made an appointment to just go watch family court in Staten Island. And one of the things I noticed from our appellate records is, and I've been a trial lawyer before for a long time before I took the bench. If I had a trial, it started and it continued until it was done. If you took a break, the judge told you way ahead of time on this Friday, we're not going to have court because it's a holiday or because I've got a doctor's appointment, whatever the reason was. But you started at 9:30, you finished at the end of the day, and you continued. In family court, you have a half an hour of testimony, and then a month later, you've got an hour of testimony. And then a month later, you've got another 45 minutes of testimony. And I get these records on appeal where the trial, there was maybe a day and a half worth really of trial time, but it took 2 years. And what's happening to a 2-year-old in the 2 years? Well, the 2-year-old is now 4. So then you file a notice of appeal, you write your appellate briefs, some people get extensions of time, it goes to the appellate division, another year maybe has gone by, a year and a half sometimes. And then the appellate division maybe takes a year, maybe takes a year and a half, maybe takes 2 years, depending on which department you're in. The second department is notoriously slow. And now your child is not 2 and is not even 6, but is 7. We had a case, Heather will remember this, I think, last term, where the child was taken away as a newborn, and by the time it gets up to us, the child is 11. So this is kind of the flip of what we were talking about with Second Look, where you ask, what is the right thing to do now? The problem is with these family court cases that what was the right thing to have been done when the child was a newborn is now almost moot.
Yes, what happens in not just Article 10 child welfare cases, but also in custody cases, modifications and otherwise, children.
Yep.
What was the wrongful, often trial court decision becomes the right decision because by the time it reaches, first of all, most people can't afford or know how to file an appeal, and most family court attorneys don't know how to argue, don't know how to write appeals, and by the time it gets to you, if it ever does, what was not in the what was the fault, the wrong determination might be ruled as a wrong determination, but it becomes the right determination because now you can't move a kid that's been somewhere for.
But I
So
think,
when I went to Staten Island, I said, look, why don't you have a trial partner?
yeah,
And the answer was, we don't have enough judges to have a trial partner. Now that we can fix, and that we've been fixing with the help of the legislature, but the problem we've run into is there aren't enough family court practitioners.
not only that, the family court is sui generis by any standard. I remember when one of our predecessors, the great Judith Kay, was trying to get lawyers to do pro bono work. And she wanted to get some of these great lawyers to volunteer to
There's
serve
only a few of
to
us who will
represent
do
people
it.
in family court. And no one wanted to come near it.
I know.
Because it's such an unusual,
Special
you know,
place.
Yeah.
distinctive place, and it's so important.
Really important place.
You know, what could be more important?
It's not sexy,
Yep.
unfortunately.
In the state of the judiciary, Chief Judge Wilson also spoke about the disproportionate number of persons of color in our prisons, and you talk about an intractable problem. Where do we even start with the problem of racism in our system? And I'm hoping Albany Law School isn't going to be losing funding because I'm bringing up this topic. Current administration. I'm sorry, you could fire me and then say, we didn't agree to that discussion. Go ahead,
Problem
Chief.
solved.
Chief.
Well, I mean, the statistics are sort of undeniable. And the problem, I think, is that you find it at every decision point. And so when you ask, well, where should we start? You can pick. I mean, there's no clear place to start. You could say, let's start everywhere. And I suppose sometimes you look at it and say, this is hopeless, so why start anywhere? But everything that you can do at any particular point makes a difference. So even things like diversifying the judiciary and diversifying even the court officers makes a difference. And can you measure that difference? No, not directly. But everywhere you can try to do something, one of the, let's say, diversifying the jury. So we're, different places in the state, we're putting ads on buses that say volunteer to be a juror, swipe a QR code. And, we're trying to diversify the decision points wherever we can do that.
Don't forget the prosecutors.
Yeah.
Because
Absolutely.
But it's what the chief says, it's every part of the system, from the corrections officer, to every single part of it. At Rikers, Karol knows it, 88% of the incarcerated people are Black and Latino. 88%, I mean, compare that to the population in New York City. I mean,
Just,
what was interesting is MacArthur did this years-long project to deal with criminal justice issues and reduce incarceration. And at the end of it, they realized that while they had reduced incarceration, they still had not reduced the racial disparities. And, it's a real thing. And what the judge says is right. It's so hard here. I want to call you Chief Justice, but it's not the New York model. But the chief judge says is right. And so I think that rather than being paralyzed and thinking, oh, where do we start? Just start.
just start.
Just
yes.
do it.
It permeates the system.
and just to add again, it permeates also the civil side because family court is also all Black and brown people.
Yes.
And that's not because Black and brown people have more family problems. It's because white people can afford attorneys and they know that the last thing you ever want to do if you have a marital problem is to go to court, you solve it outside of court. But we force Black and brown people to make use of family court because they can't afford any other alternative.
So
And
we
so
had-
then they
we
get
had-
forced into a system that is not meant for resolving family problems.
We had a neglect case come before us last week. I can't obviously tell you anything other than facts you could find from the record, and there's very few that I would need to tell you to illustrate this anyway. But basically, the mother was deemed to have neglected her children because she had the 14-year-old watch the 5-year-old, and the 5-year-old on 2 occasions was found wandering the neighborhood unsupervised, and the 14-year-old was asleep. And on another occasion, she had the 9-year-old and the 7-year-old take a bus to meet her at work, a public bus, one time. So previously, before I lived in Manhattan, I lived on Long Island. And there was a family that had 5 boys. And the youngest boy, who was maybe 2 and was in diapers, was frequently found by himself wandering around the streets. And what would happen is somebody in the neighborhood would pick him up, carry him back over to the home where he lived, ring the doorbell, and then he'd go. ACS never even knew about it.
Give us a solvable problem that's
Yeah.
rather than these.
Yeah. So what
But
are the
that's,
kinds
see,
of
that's,
things?
but wait, but that's a solvable problem, right? That's a solvable problem because instead of running this woman through the neglect
Right.
system, you have resources that say, look, you're working. Your 14-year-old is not a reliable babysitter. What is it that you need that we can do so that you can keep, otherwise there was nothing that I saw on the record indicate that she was, a bad parent. And you see cases like this all the time. There was another case, it wasn't even a case, it was a motion for leave, where the father was judged to have neglected his child because he got very angry at his wife. And he left the house and got a brick and threw it through the window of their car. Nobody's in the car. I mean, counseling, yes. Neglect determination in court, does that make sense?
And I mean, I want to disagree with you. I said, I don't want easily solvable problems because that's not why you're here. And I think that what we need to do is realize that we can all do something. And I think instead of getting paralyzed and thinking, oh, the problem is too big, think about where your place is in the system. So another initiative I started when I was at the Department of Justice was I was worried about this disproportionality and the disparities. And actually, the then president of John Jay came to me, he wrote a letter to me in the Department of Justice after the Trayvon Martin murder and said, there's a whole lot of distrust between communities of color and marginalized communities and law enforcement. You all at DOJ should and could do something. And so I cobbled together enough money to create something called a national initiative to build community trust and justice. And we started focusing on law enforcement because that's the entry point where most people have some interaction with the justice system. By the time, if you can stop it there, then you can stop them from getting to the judges. I'm not thinking about the civil side. That's a whole different complexity. But the expectation was that we would always be thinking about other places in the system and working on these issues there. And I keep saying it's a question of will, and do we want to do it? And you young folks here, you future lawyers, I'm hoping you're learning about these things that I didn't learn about until my 50s. I was a practicing corporate lawyer for 30 years and then went into public service. I hope you think about these things early and think about, regardless of what practice you go into, you have a voice, you have a position, you have a perspective that can then help make changes. I mean, look at Judge Wilson, he practiced corporate law, as a litigator, but for years, and then went into public service. You can do both. You don't have to make a choice. And think about where you can push policy issues, where you can go volunteer and do some things, and think about where there are places for you to make changes. And when we talked about, the juvenile justice system and points of intervention and the whole system of where you can make interventions, it's, we talk about job creation, safe, healthy housing, education, mental health, all these things. Think about where you can make a difference, or people in your family can make a difference in pushing your communities to invest in these things. You're all taxpayers, or will be. You're all voters, I hope. Hold people accountable who make these decisions and make them make these systems work so that woman doesn't have to choose between childcare and working to support her family. We ought to have affordable daycare for people.
Talk about
Well, I think
systemic
in
issues.
in the justice system too, I think we have to recognize that there's a continuum between the civil system and the criminal system, that one feeds the other.
Right,
You know,
that's what I
if the civil system, maybe there's some of the things better, these people that be in the kids or anybody else in the criminal system.
Right.
So one of the things we've been, John Jay, we also run the Institute for Innovation and Prosecution. One of the things that we've been doing is looking at I learned this word in academia, intersectionality. We just had a big conference last week with prosecutors about homelessness and thinking about, the intersection of working with people and having prosecutors being engaged in their communities and thinking about things so that they're not criminalizing them and having them in their criminal court system. We did the same thing with immigration, did the same thing with women's rights issues, health issues.
So I think one good point of entry is community policing. And those are the police on the streets. And as James Comey once said, it's hard to hate up close. One of my favorite lines, right? And what he meant is, when you know the people in the community that you're serving, they're not just anonymous numbers to you. They're people with lives who matter to each other, and should matter to you and to all of us in the community. So I think that's important. And also, you brought up a good point about, Judge Lippman brought up a good point about prosecutors being held accountable civilly. I mean, when prosecutors hide evidence in a case, or there's prosecutor misconduct in a case, are we holding them civilly liable, right? And it seems like when courts find that there is some liability on behalf of a prosecutor that changed the determination in a case, and somebody goes to prison wrongfully, are they held accountable? And it seems like there's no automatic referral of that misconduct to a grievance.
Well, remember, there's been a lot of legislative initiatives
Well,
about prosecutor accountability, and it's had a very checkered,
So-
history of trying to get that.
so we just staffed up the Prosecutorial Conduct Commission. It was introduced in the legislature in 2015, 2018, Andrew Cuomo signed it. 2020, Judge Weinstein said something about the structure was unconstitutional. By the time we staffed it up, I just want to say it was late 2024. It's got a staff of 10 and it's got a panel of 11. And within the first October, November, 3 months of it being on board, they got 142 complaints.
Well, the United States Supreme Court has been diluting the heck out of causes of action for constitutional torts. The our own Court of Appeals, of course, in Brown versus State, right, we established, Judge Richard Simons, writing the majority opinion, established there could be a state constitutional cause of action. But the Court of Appeals, I mean, to be candid, really hasn't done much to move that forward. But getting back specifically to race, what can we in the law school do? As a professor and as students, what could we do to make these issues of race come to life, whether we're teaching criminal law, constitutional law, tort law, anything, everything that you teach? I mean, what can we do to make this come to life? Because sometimes it's very uncomfortable for students. So we wouldn't be able to do this in Florida, but I mean, but you know, sometimes it's very, how could we bring, I'm asking for your advice, how do we bring this to life so that students understand? What do we do? Come on, you're the chief judge.
Bring some real people in here.
I'm sorry?
Bring some real people in here.
And not worry about people being uncomfortable.
Oh,
Yeah.
Well, that's for sure.
yeah.
An interesting thing happened at Siena, I think it was 2018. I'm struggling to think if it was 2018 or 2020, but I was teaching a course on wrongful conviction. And so we decided to put on the, we didn't put on the play. I brought in the Black Theater Troupe of Upstate New York, Remy Onet, and I asked him, because I knew that he had done this play, The Exonerated. I said, could you bring it to Siena? And they brought it for like 4 times. They did it within a weekend. And every night of the play, we had some exonerees in the audience. And then they would come up at the end and talk. And, you know, sometimes things happen by accident. Sometimes the best things that happen by accident. What we wanted to do was show everybody how awful wrongful conviction was. But what ended up happening was the audience was asking all these questions about, they learned about the awful conditions in prison for anybody. Right, so that's what the questions were about, actually, more than about the wrongful conviction, which was really, really interesting. Felt like we had built some allies on the outside for terrible prison conditions, which is interesting. The other thing that was really, really cool was one night, there was a guy named David McCallum, who was the person who was in the audience, the exoneree, and he came up on stage. So David was, I think, the first exoneree from Kings County. 2011 was when Ken Thompson, late great Ken Thompson, started the conviction review unit there, or conviction integrity unit, same thing. And David was one of the first cases, not the first case. And he was in the audience and he came up on stage and he said, I have to tell you all a secret. I knew about this case when I was incarcerated. I mean, I knew about this play, sorry, when I was incarcerated, and I memorized it. And while they were doing the play, I am saying every line in my head. And I thought to myself in my cell, when I read that play over and over and over again, one day I'm gonna get out and see that play. He said, and I just did. And there was not a dry eye in the theater. I'm going off topic, but so we brought people in to talk about wrongful conviction, and we ended up talking about conditions in prison. So telling stories is important.
I think with all the wonderful work that places like the Innocence Project have done, some of our decisions in the court, I think we're still missing the boat for convictions that is really not an understanding. And I think you said it, Judge Wilson, and one of the others is, it's so much better to let a guilty person, if the balance has to be that a guilty person is going to go free because you're ensuring that no one is convicted. The worst thing that the criminal justice system can do is have an innocent person convicted of a crime that they didn't commit. What could be worse? And if there's a balance and something has to fall by the wayside, if a guilty person, I don't know how you want to describe it, gets off the hook because you're zealous in ensuring that no innocent person is convicted of a crime, then you're at least avoiding the worst travesty of what the criminal justice system can do. And I still think that with all the work, good work that's been done, the issue of wrongful conviction still needs to have more of an understanding, whether it's the cases we've had, that a person could could actually say I committed a crime when they've been held for 25 hours or whatever it is. It's inconceivable to people that someone could say that I committed that crime when they didn't do it. And you know what? From so much of the work that's been done, we know that that happens so often. Identifications, false identifications based on so many things. It can be racial, it can be, you know, you don't know it, but you're not identifying the person right. I think wrongful convictions is still an area that requires our attention and focus.
So I think that the racial disparities are across the spectrum. The racial disparities are in the wrongful convictions. They're in the disparities in sentencing. They're in disparities in prosecution. You've got a good lawyer, you know, a well-paid lawyer, you could do the same thing and your lawyer can get you off. But if you're poor, you don't have the same right. So I think that, again, we need to be looking at all of the places of intervention and thinking about how do we, you know, ineffective assistance of counsel is a big argument because public defenders are overworked versus people who have money. And so the question is, how do we invest more in our public defense system so that they get adequate representation? And so they, and you know, another point you raised is that most cases don't go to trial. It's plea bargained. And again, we need to look at the systemic inequities in the plea bargaining system. The people with rich lawyers
Right.
have a better chance than those.
As the chief said in the dissent in the case that you sent out in, that, yeah, it's great that you did
Tiger
effective
case.
counsel.
Tiger
What
case.
about the fact, is the person innocent or not? You know, and
Right.
what did you get to the bottom line?
Can somebody speak a little bit about plea bargaining and reform? Because in my experience with criminal law, we are in a system that is almost impossible to fight anything that everyone is encouraged to plea bargain everywhere all the time. I practiced in criminal court in Georgia and there was one trial in like 5 years I was there that ever went forward. So what are we doing about that?
These things are all sort of interrelated, right? If you look at the average sentence of somebody in New York from 15 years ago, it was 9 years, and now it's 13 years. And that doesn't even, there's also the, persistent offender statutes and so on. So the problem is you're a defendant, you get charged with something relatively serious. The amount of time you could spend if you are convicted is an amount that's unbearable. It might be life, it might be 40 years, something like that. And so you're offered
Right,
12 or 10.
right.
And it doesn't really matter in that calculus whether you're innocent or guilty, because the risk that you will never
Right.
see the light of day again, that's the problem, is that
Right.
The-
So
the-
what are we doing about that?
well,
I understand the
yeah.
problem.
Well, there's an audience here too. Maybe not everybody is as sophisticated as you. So that was a lead-in, if you
Right.
will. What do we do about it? So one of the things we have to do about it is reduce the maximums, right? Second look is another way that you attack the same problem, but from a different end, right? Because you've plea bargained for every plea bargain, you don't necessarily wind up that way. And people, if they know there's another chance that their sentence will get looked at, may be less eager to take a bargain because it's then a different bargain. Part of the other problem, I think, is that both the prosecutors and the defense attorneys are overworked and couldn't really, when we say most cases are plea bargained, it's like 98%. It's not most, it's essentially virtually all.
As I mentioned, I saw.
And if that changed so that it was 80%, nobody could handle that trial volume. The courts
Right.
couldn't, the prosecutors couldn't.
But
So-
we all know, if, for those of you who are not lawyers yet, if you work in a courthouse, you know that your court-appointed lawyer, whether it's family or criminal or whatever, is gonna come to you and be like, look, this is what we have. They're not gonna believe you this, blah, let's just do it, let's get this done, and bam, done. And suddenly you have a custody order that you don't like, or suddenly you have pled to something because of the overworked, but like that's not changing. And we can talk about all the stuff in the world, but like if the reality at the courthouse is court-appointed attorney telling you, you have no chance, or you should just take this and let's just get rid of this, and that's what everybody wants, then that's what's gonna keep happening.
Yeah, but that's the excuse we all give. We've defended the overburdened defense attorney, not enough judges, all of the above that produce plea bargains.
Right.
But you're right. How do you get to the underlying issue when you do? And those are real things, you know, the under resources. How do you defy the gravity of the math that tells you that you have to do, what did the chief say, 98% of the cases that
Right.
to have the system function? There must be a way, but no one's found an
Right.
answer yet.
I
How about a system where we incentivize justice rather than incentivizing wins?
time, right, and also
You know, I mean, and
efficiency.
so the
That's like
prosecutor.
that, though, Karol.
I mean,
I've
so
seen
that, and it's hard, but so that you have prosecutors who, and I've seen DA Gonzalez is trying to do this. I was there when he released his 2020 report,
Great.
trying to,
You-
trying to figure out how to get his prosecutors to say, I really want you to figure out what's just and what's
Right.
right. And I'm not going to reward you for the number of cases you resolve and dismiss. Is this person, I mean, I think that we've got to change the incentive model, change the thinking model so that the prosecutors and the defense counsel aren't always adversarial in the sense of they both want to figure out what's right, what really happened.
Change the culture, right?
Yeah.
Right.
When we had to decarcerate during COVID, we saw that the crime rate did not soar, right?
Right.
So that should have been a good message to us that maybe we need to do things differently.
Right.
And one thing that was supposed to curb the plea bargain problem, well, one of the problems I hear from defense attorneys all the time is that we don't have the full information
Right.
plea bargain stage.
Right.
And you're asking me to advise my client, it's malpractice
Right.
on whether to take the plea or not, and I don't have all the information. So that was one of the things that discovery reform was supposed to help. I don't know. Yeah.
Well, I don't want to let judges off the hook because, I mean, for example, like in the Tiger case, the only reason she pled guilty was because the lawyer says, we don't have the resources for an expert.
Mhm.
And if we go to trial, you might get 7 years. So she says, but I'm innocent. Well, but I'm advising you to plead guilty. I mean, what about the trial judge? I mean, does the trial judge hear about that? I mean,
Well,
what
Tiger's a
happens
little
and why
different,
should the
actually.
trial judges accept that
Except,
plea?
right.
Tiger's a little different, right? She didn't say she was innocent. She mistakenly thought that she had burned the baby by putting
Oh,
the
she
baby
mistakenly
in, right,
did,
because it
yes.
turned out the baby had a rare, not a child, it
Right,
wasn't a baby,
right.
rare allergy to water. She didn't know that. It was only when they then sued the agency and the agency was able to afford real lawyers and they dug through the medical records and found something that they weren't able to turn over to expert, and they tried the case and the agency won, that all this about the child's condition came out.
But she was insisting that she never used scalding water.
She didn't mean to do it. But she was
Yeah.
really contrite. She's a professional nurse and
Yeah.
it was unthinkable to her that she had done this, but she was, consumed with guilt about it.
And then your court still upheld the conviction.
Right.
But that's why there's an appellate provision, because they were able to overturn it after us.
Right.
The interest of justice. I'm
It
sorry?
was the second department, but still.
Yeah.
No, I was just gonna say, I think though, the issue of the allocution or of the judge approving things is also an issue. They are also a part of this problem in both civil and criminal courts with people not being fully advised or not understanding what they are pleading to or agreeing to.
Well,
And
that's
then-
basic that the judge should handle.
Yes, but then you also it's,
And why can't we get the courts to accept actual innocence as a defense?
right.
What's the problem with that?
Heaven forbid,
Yeah,
you know.
I mean, the problem with that is that we have an unfortunate ruling in which I dissented
yeah.
that says that, but the legislature has pending legislation that gets introduced, and the last version I saw of it from last year was trying to bite off too much,
Yeah.
as sometimes the legislatures want to do.
Mhm. Yeah. We should ask the students.
I'll tell you, my hope after reading all of his dissents is that his dissents become the majority.
That's why
That's
we
my
did,
hope too.
that's why we do dissents.
I think we should open up the floor for questions. I know the students actually have quite a few questions if they're not too intimidated to start asking them right now, but I know they have They actually have plenty. So, don't be shy. You scared
there's-
them, chief.
There's
Me?
someone
We
else.
have, we do have somebody
up
way up in the ambassador. Yeah,
Yep.
bring him up.
I think we're bringing you a microphone. Hang on.
Then after the first one, they start rolling. Yeah.
Hello, my name is Basir Rizik. I'm a 1L. We've gotten into a lot of detail just about crime and punishment, but I kind of want to just understand the discrepancy that I see with punishment, because we were taught here, just as I've been here, that law is ever changing. Why hasn't that applied to punishment? Why are we taught that it's like so rigid, and why has it been so rigid? Is that a state by state thing? Is that within the system itself? Is it teaching us that? Because in high school, I did youth court, which we took on juvenile cases, and we were kind of almost taught to like give the utmost punishment, which was like community hours or a class. And I feel like that's what I was kind of noted with as I've been growing up and coming to law school. So why is that? Where did that come from? I just would like your thoughts on that. Thank you.
It's been the historical paradigm for millennia, is you do something wrong, you go back to the Code of Hammurabi, it's more severe than the laws we have now. And that's 4,000 years ago. But it's a knee-jerk reaction. It's not a thinking reaction. One of the things that the message that I've been trying to deliver through not just the state judiciary, but through everybody I talk to in the court system and outside is, we really need to think about what we're doing as solving problems, not as punishing people or deciding what's right and wrong. And that's even true on the civil side. We have a problem. People have a problem. They are real people. What can we best do to help them solve that problem? So it works out well for them and for the rest of society. That's the way we should be thinking about it. The problem is we've been thinking about it a different way for 4,000 years. That's the problem.
I think the other issue that we've tried to get across to people, judges are there to exercise judicial discretion. And legislators for so long have tried to take away that discretion and make punishment mandatory. And why in the world do you have judges if they can't use the wisdom, their understanding of the law to figure out what's an appropriate punishment or result? And what the chief was saying in terms of problem solving, what's the consequence of what you do as a court when you put a particular punishment, a particular resolution? How does that affect the individuals who came into the court? That's what problem solving is about. But I think fundamental to the issue you raise as to punishment, should it be, the maximum? Let judges have that discretion. This idea I found offensive, that judges can't be trusted.
Right.
Well, why the hell do we have the system that we have
Right.
if judges can't be trusted to exercise their, quote, judgment?
I think that the default that you're talking about, to default to jail and default to punishment, is endemic across the whole system. It's not just, and as you said, you were doing it in a youth court, and your default was somebody must be punished. And there's been a lot of movement of trying to have restorative justice and thinking about other things so that the default isn't that somebody's got to be punished. It's trying to figure out what's the right outcome that serves everybody, as Judge Wilson said. And so I think that unfortunately for you all, I think that what we need is a culture change, and you all can be that culture change. I mean, it's got to be younger people that push the envelope on these things, because we have failed. I'm just saying, we have failed in changing some of these cultural things, and you all can do this. And I think you just have to keep talking about it and pushing it and insisting on that it is not the default. And it's not just judges, the default in who gets arrested, the default in whether the prosecutor decides to prosecute. There are lots of people that when things happen, our default is always arrest, our default is prosecute, our default is incarcerate. got to change that model. Other countries do it. Why we don't do it, we just need, we need, again, it's about the will to make
You know,
changes.
Karol, when people have challenged the system,
Uh-huh,
like when we try to help the DA Gonzalez
mhm,
challenge all the premises of the
mhm.
criminal justice system, you can take it up to a point. But the system sort of has a life of its own, no matter how hard you try, and some of the good progress you can make, the system is like
I also think another piece that you all alluded to, which is missing from this, is that very often legislators are not people who actually practice in their courts and see what is actually happening. As someone who used to be an attorney
they're not even
general.
lawyers.
Right, as someone used to be an AG and having to defend or do the state, then when you look at what the law doesn't make any sense. And so you are in a position, you're like, who wrote these laws? They don't make any sense. And so you're fitting them into a system that the people who wrote the laws aren't practicing or aren't lawyers or aren't,
So, what we've been doing is we've been working with legislators while they're drafting legislation. We've been actually bringing them
Right.
into the problem-solving courts to see what they
That is a
do.
way,
That's
yes.
great.
That is,
And we say to them, why don't you come to us?
right.
We deal with it.
If you had not put
Oh.
this one word right here, I could have been, ruled.
John Brathwaite says, crime hurts, justice should heal. And we don't do a lot of healing. And frankly, incarcerating people, not only does it not work, but it costs a lot of money.
Mhm.
I mean, it's like $500,000 when you add up everything per person in New York State, when you add up the cost of the correctional officers' salaries, et cetera, et cetera.
Rikers who haven't been convicted of anything.
Right.
Most of them cost $440,000 a person per year.
Like 70
and
to
they haven't been
80%.
convicted. They're just sitting there.
70 to 80% of people in jails are not yet convicted.
Right.
Maybe they never will be, but we're paying for them to be holed up there, right? And it doesn't even work. So, England a few years ago, now in their courts, there's a requirement that judges look at restorative justice options before they sentence someone. It's required. I don't know why it's not required here. It would require a paradigm shift to make us look at that. But, it's not hard to be it's hard to be incarcerated. It doesn't require hard self-searching to be incarcerated, right? You're angry because you're incarcerated, but, and you're losing a lot out of your life and your family's life. But when you force someone to go through, or you ask someone to go through a restorative justice process, they have to hold themselves accountable. That's the hard work. And so anybody who says, well, restorative justice doesn't work, it's soft on crime. It is not soft on crime. It not only makes people hold themselves accountable and think about the impacts they've caused, but it also works. The recidivism rate is really low because people are transformed, and that is the healing.
Chief Judge, when you have these annual institutes for the judges, okay, you asked me to talk about the Supreme Court, Pat Connors to talk about the CPLR. Do we have people talking about this?
We do have people talking about this.
Yes.
We have people talking about this also in ways that are more oblique, but also relevant. So we have people talking about brain science, right? When your brain is formed, and things like the science of addiction, so that they can understand a lot of the biology as well, which then informs how they treat a case when it comes to them. They have a deeper understanding. It's not just, well, this person held a gun to somebody, and so I put this through a calculator, and here's what the answer is. They start asking the why. And I think when you start asking the why, you then can start asking, and then if that's the why, then what should we be doing to avoid this in the future and to help this person and the victim? So there's a lot, there's a range of things. There's some that's traditional, like you.
Right, but do you have people who are criminal justice experts, like we have here, talking about this stuff? Because
We do.
we
have-
all need
have
it,
People
and the
coming
judges
talking
need it.
about restorative justice. Absolutely.
Absolutely. Annie,
I
you
was
didn't
gonna
want to
say,
tell him
maybe
what
the-
he should be having
I was going to
judges
say
taught?
that, I forgot which particular office it is, that runs the judicial education.
Yeah, Judicial Institute.
Yeah, And so they brought in our data collaborative for justice at John Jay to talk about statistics and things and understand things. For example, the narrative that's out there about bail reform. So they brought our folks in to show them what the real data is so they could make informed decisions. So I think that that's also something that people ought to do is look at the research, look at the data, and have it inform what you do. And so I know the judges have been looking at those things.
Just another little plug for restorative justice. You, I only know this because I recently went through it with my daughter. They use restorative justice in schools now, and it is so effective. She's in middle school. She had something that she was discipline action, and she had to go to a circle, and she told me all about it, and I was like, wow.
Yeah.
Like that, we can do things, but we need to do them early. We need to have them be a part of our cultural thinking about how things can be better, because when I went to middle school, if I had done what she did, I would have been probably sent to the principal, whatever, suspended, whatever it was. But now she's reformed and she's perfect.
See, that's the great thing about growing up in Berkeley. When I was in fourth grade, another kid and I had an issue, and we actually had the teacher and another teacher brought us in for a restorative justice.
Wow,
Only in Berkeley,
Only in
right?
Berkeley. Only in
that's
Berkeley.
incredible.
In Del Mar.
There you go.
Okay.
One of the things you mentioned that people, we haven't talked about is the victims community supports a lot of the things we're
Yes.
talking about.
Yeah.
They're not in favor of, these long exorbitant sentences
true.
and having people locked up forever. And so I think that some people use that as an excuse, but if they actually talk to the victims community, they're on board with the changes.
And actually, the thing they want the most is for it to never happen again to anybody.
Overwhelmingly
that's the
so.
most
Every
important thing.
victim survey says the same
Yeah.
thing. They support all the right things.
Well,
We-
well, if you went to Catholic high school like I did, when I did, if you had a problem, they'd send you to the principal's office and he would beat the hell out of you and problem solved, I mean,
Right.
yeah,
They did that.
literally.
Right. They did that in public school when I was growing up
Oh,
too.
really?
Mhm. But my fourth grade teacher had something about baby Leroy, Papa Leroy, Mama Leroy. That was the name of the paddle.
But you can do things on a small scale too. So at Siena, I'm on the Student Conduct Review Board. I insist on being on the Student Conduct Review Board. Even when they tried to get me off of it, I said, no, I want another year. But it used to be pretty standard for student conduct review. People got suspended, they got fined, whatever, lost housing. And now we're doing much more innovative things. So I won't mention any names, but there was a student this year who got caught peeing in the woods on the way to a Halloween party on campus. Literally caught with his pants down, right? And instead of giving him a suspension or a fine, which he would have gotten, we made him make a P chart. And the P chart was, you had to take every building on campus and show where the bathrooms were and the ones that were open after hours and not open after hours, so that everyone knew, so this wouldn't have to happen again. Because when we questioned him about it, he said, everyone does it.
Right.
We were like, well, we've been on campus a long time. We've never peed in the woods. So this is what happened. And, but that's the kind of thing that it packs a punch. I'm sure he's not going to do it again. But it also helped other students not have to pee in the woods.
But what
No.
you talked about is, I think about Martinez, who spoke at your when he was 17 and what happened with him. And you talked about the school to prison to pipeline. I like to reframe that language, and what we're talking about, we ought to create systems called supportive discipline. And so you're supporting kids staying at school, even when I'm 60, almost 68. So I'm talking about, I used to wonder back then, why reward people with suspension? They didn't want to come to school anyway. I was going to say, what you need to do is figure out how to keep them in school, not out of school. And so thinking of a more supportive model, again, there's lots of literature out there, there's lots of things to do, we know what to do, and creating an environment where you're talking about keeping kids in school and on the right track and out of our criminal justice systems. That's what we ought to be doing.
Question. All the way in
One
the
there,
back.
one there.
Oh, you too, Rosalie.
Hi, my name is Rosalie Desir, and I'm a 1L. And I guess my question is, do you think that putting a focus on intersectionality when it comes to 1L classes, that would kind of help like this issue because I feel like a lot of our classes, I mean, again, not like dissing the education system, it's really good. But just like, I feel like a lot of our class, like when we're learning about the law, it's really taught in almost like a black and white way. And of course, we have like those private conversations with professors where we kind of get more into it. But like when we're reading cases, it's kind of taught in a way where it's like, I guess like this person is guilty of murder, and that's really the only way of looking at it. And of course, that there are the dissents, but I'm just wondering like, if we put like more of a focus to, I guess, on intersectionality, would that help the issue in just making us as, you know, future attorneys look at the law in a more nuanced way? Yep, just gonna.
Yes, but it'll be harder if you get a job.
Yeah, yeah.
I mean, I'm so far out of law school, I was looking for you, but I remember having this conversation with some of our students a lot of our students at John Jay go on to law school. And I remember one of the fellows in my office, he was just so frustrated with the conversation in law school. And I think 1L is different than second and third year. I think 1L, they're just trying to get you to understand how to think like a lawyer. And then I hope that in second and third year, that you're really getting the nuance and getting the understanding of thinking about where the gray is, where there are opportunities for really thinking about things. But I think to pass the bar exam, you got to know what mens rea is. You got to know, you got to know
Should-
these things.
You should
Um,
take an in-house clinic such
I
as
was
the
gonna say-
family violence litigation. Or
go to
any of
court.
the other
Courts
offerings.
are open to the public. Sit in court and watch and see the lives before you. Yeah. And see the crying family members and all that stuff. It's important.
Or go every other Friday, I think, in county court here to Judge Ackerman's court.
Hmm.
It's UCAN court, so it's for kids, it's people who are under 25 who were arrested for something but are being diverted. They come every week and there's follow-up, and it's really amazing to watch. And, sometimes it'll seem like they've done something that's a trivial violation of the rules that are set out for them. They'll get put back in holding for, not in jail, but there's a holding area. They'll get put back for a week or something. But it's a very structured, very successful program, and you can watch it, for free, a couple hours every afternoon on every other Friday, I think.
I didn't go to Albany Law, but so I was.
Wanted to.
I did. I really wanted, but I wasn't even up here yet. But the thing that was, I think the most important course I ever took was a clinical course. And we were mediating cases in small claims court in New York City. I learned more than I learned in any classroom doing that. I learned about human beings. And what the most impressive thing that I learned in those courtrooms every week when we went was that people didn't care about the money, this was small claims, so it was about money. People didn't care about the money. They cared about the apology. They wanted to be respected. So when a dry cleaner ruined somebody's very expensive leather jacket, he didn't care about the leather jacket. He wanted the dry cleaner to say, I screwed up. I'm really sorry. It's my bad. And case after case after case, it was so impressive to me, like as a young law student. I think it really changed the trajectory of my practice, of where I went after that.
Hi, I'm Tom Smith. I'm state reporter of New York. I'm not a student, and I'm a state reporter. That's Judge Wilson's fault. I wanted to tell you about my career. 38 years ago, I was a legal aid lawyer in Brooklyn. 35 years ago, I was an 18B lawyer in Brooklyn. It's a noble profession. My colleagues were great. They were very good at their jobs. We never tried to talk anybody into taking a bad plea. We tried cases when they needed to be tried. And when we won a lot of cases and we lost a lot of cases and we pled a lot of cases too. But I want the students to know that being a public defender or assigned counsel is noble. It's a good thing to do.
Absolutely.
And a hard thing to do.
But I hope we heard us saying is they need to invest more in them so that they hire more, pay you better, and so that you can do this work.
Right.
Agreed. My son's a public defender. He would agree.
Hi, I'm Nathan Taylor. I'm a 2L. I'm from a small prison town about half an hour south of here, Cooke. And Cooke wasn't always, what it is today. In the, it was a kind of, born of New Deal idealism, opened in the 30s as the New York State Vocational Institution. A Florida, University of Florida historian wrote a history of the prison and its evolution to what it is today. And one of the main factors in making it, taking it from being a vocational institution with farms and blacksmith shops, all kinds of different workshops was the increasing power of corrections officer unions and their resistance to a lot of the progressive policy changes that were attempted. And just last month, we saw corrections officers unions striking. I drove past them on my way home. And I'm just curious if you could offer any comments about the role of these forces and how you accomplish progressive change despite their resistance, or how they should be involved in the process, et cetera.
Well, I can only tell you that they sometimes do stand almost just you can't understand it against progressive change. I think it's the nature of their training, what we tell them that their jobs are, what their culture is. One of the things that we've been doing on this Rikers Commission in the city, which Rikers is the worst place in the world. And part of it is because the corrections officers have a certain view of the job that's all about punishment and not at all about what was the expression that the commissioner is taking care of people who are in our care. So one of the things that we've emphasized is that we have to change the whole job description of a correction officer, how they're trained, what they think is important in what they're doing. And maybe the union will come along. You take, for instance, in relation to Rikers, we've been talking to them in years and about this and how it would be better for them to be safer places, more humane places, safer not only for the people who are in the jail, but for the people who work there. But it's a hard concept to get across. I think it goes because they have a very single-minded view of what they do. So I think it's changing a culture, and changing a culture is not easy. And I think the unions reflect that culture, and you get, like anything else, some union officers who are much more enlightened than others, and it takes work. And as I said, changing the culture and talking to them, not ignoring them, because I don't think it's a universal thing that they oppose every, progressive change to jails or prisons, but it is a problem. And as our unions, look, you have criticism of public unions in all different fields, whether it be, the teachers or the police unions, or, well, there are problems that go with the role of the collective bargaining and the union officer and how they represent their people. But in particular, when you're talking about corrections officers, I think it has something to do with the way the job is viewed and how you attract quality people, educate them properly, and change the way they view their job. And maybe it also change the view that the people who represent them take as to various issues,
So I think we've got at least two opportunities. So we run a program at Otisville Correctional Facility at John Jay, where there are students, and they can now, thanks to a partnership with the Borough of Manhattan Community College, we can actually award degrees for people who are there. One of the things when I first went to Otisville to meet our students there, and I heard some of the corrections officers griping and saying, they get to get a college education and I can't afford to send my kids to school, to college. And so there's an opportunity for us to, so it's not in them versus us, thinking about what I tried to do and then COVID hit, was think about, why don't we do our educational programs and allow them to participate, the corrections officers to participate in the college classes too? So it's not, so that they have an opportunity as well. So I think that's part of it, is making sure they have opportunities to grow. The second thing is those of us who are educating the future corrections officers, a lot of our John Jay employees, students go into this field. I want them to understand that they're not, that their role is that they play a key role in what I tell them is public safety. Because most people who are incarcerated are going to come home, and your job is to help them come home successfully and getting them to think of their role as caretakers as part of the solution, and not just there as, there's a reason why we don't use the word guards anymore. We try not to use that, because that's not what they should be. And so I think that we need to be looking at opportunities for them to feel like we're investing in them as well and their futures as well.
You know what, Karol, I think fixing the institutions also would help, because the one thing they are concerned about is coming home in one piece
Right.
at night. And it's hard to take a more holistic view of their role, when all they want to do is survive.
Right.
So if we fix the institutions a little bit that they served in, I think it would go a long way also.
Also, lest we not totally bash unions. I lived for a long time in the South and there are no unions, and this is still a problem. So it's not the union per se.
To work state?
Yes, I lived in Georgia. There are no unions.
They said a right to work state. I was like, that's not what it is.
Right. So they still, it's not, right, it's not, the union is a symptom of a problem of what you're describing, but the union per se is not is not.
Not necessarily the problem.
Right, because the
Just
Georgia-
like,
right.
just like asking high school teachers to use restorative justice practices instead of disciplining, suspending, expelling students. Correctional officers need to have buy-in and need to see why, when you have dynamic safety, meaning people who are incarcerated are learn how to resolve conflicts peaceably and de-escalate conflict. It makes a calmer place to work, and it's better for everybody. So when you have programs behind bars that have people focusing on their work, their skill learning, their trade learning, their education, that helps everybody behind bars, and it creates a much safer environment. But you got to get the buy-in of the correctional officers that it really is for everybody's benefit.
You know, but I think too that understanding that you're dealing with human beings are important. And you take places in other parts of the world, like in Germany, where they went through the Holocaust. In their prison system, it's written into the constitution of the country that in the jails and prisons, that these human beings who are there have to be treated with respect and dignity, because they recognize, because of what they went through during that period, that treating anybody as less than human is the worst thing you can do. And it's so interesting that here we are in our enlightened country, and we don't treat people who are in penal institutions as human beings, or often we don't anyway.
I wonder if I could ask each of you to give some final words, reflections, wisdom, encouragement to the Albany law community, especially our students. Chief Judge Wilson, can I ask you to begin?
Sure. Well, I'm an optimist. I'm maybe an incurable optimist. So I think that those of us here and a lot of other people like us have been planting seeds for all of you. So you're going to start in a better place than all of us started. And so that's the first bit of optimism. And the second maybe just comes from my Berkeley upbringing, that sometimes what's needed is really radical thought. It's not, how do we tinker with what we've got? How do we make that a little bit better? It's, wait a minute, why do we have this at all? If we had a blank slate, what would we do? And to not be deterred in thinking about things like that because they seem very different, or they seem very expensive, or they require a lot of heavy lifting. You know, I think something you have going for you is something I've said directly in my last State of the Judiciary. This system, we've had it for a very long time in its basic form, and it isn't working. It's not working to keep people safe. It's not working to keep people out of prison. It's not working to encourage people, to help them have good lives. And I wouldn't think of it as a penal system or a criminal justice system. It's a broad, complex social system that has a lot of interlocking parts. And it's up to those of you who are, 20, 30, 40 years younger than I am, than we are, to break those things and start over. And I think we've helped you some, but there's a lot of heavy lifting for you. And I hope I live long enough to see some real change.
Well, I take the prerogative of affirming everything that the chief judge just said. And my final comment would go back to what I started with when I talked about the chief state of the judiciary, that bringing that human element and seeing those human beings who have served in, penal institutions forever, and are either out after 25 years or aren't out. Putting that human dimension is so important. And I bring it to the last comment about corrections officers and how if we treated the people in those institutions as human beings, it would go such a long way. And I think the criminal justice system is just that. It's about human beings. And if we could just put that human face on all the different aspects of the criminal justice system and understand that respect, humanity, dignity of every single person who comes through that continuum that we're talking about, that is the criminal justice system, I think it would function a lot better if we could all put that at the front of our minds, that these are flesh and blood human beings who need to be treated as such. That's the kind of criminal justice system that we want, first and foremost, the hallmark of that system. Karol?
And so I love the theme of your program, and you end up with, you start with failings. We've covered that well. We've talked about some possibilities, but the word I land on is aspirational. I am a hopeaholic. And I do the work that I do at this age because investing in you all, and why I said yes to doing this is because you are our future. And I love Judge Wilson's phrase about radical thought. You all are the generation that always asks why. And so you have the opportunity now not to just be satisfied with our answers, but to redo things. And so I think that we all have a privilege in this room as lawyers, as people who have an education, is that you have a privilege that you have an opportunity to make a difference. And what I hope that you all do is seize that opportunity, block out all the noise. I know you're worried about your futures and worried about what's going on in the world. Block that out and focus on the opportunities that you have to really make a difference in this world and seize that. So that's my parting thought.
I wish I'd been sitting in that seat because I'm going to say something very similar, but the program that I run at Siena is restorative justice focus and transformational justice focus. So it involves a lot of critical thinking, and we're always challenging students to reimagine the criminal justice system as it might be if people were treated more equitably, humanely, with dignity and respect as they deserve to be. And so that would be what I would challenge you to do. Always question, why are we doing things the way we're doing it? Can't we do it better? And go at it with a lot of empathy and connection, really, really, really important.
Well, thank you very, very much. This was
Great to see you too. Oops, you still mic'd up.
Thank you, everyone. That concludes the symposium. We now invite you to join us in the East Foyer downstairs for a reception. So please feel free to make your way down there.